this is not only about our First Amendment right to speak.
But here's the thing about the First Amendment. The First Amendment protects free speech. It doesn't protect lies that amount to defamation. And that was the issue in the case.
Yes, exactly. You can't go into, the free speech does not protect you if you go into a crowded theater and you scream fire. We get the concept of free speech from the Greeks. My understanding of what that means is not just the freedom to speak. It's a freedom to speak truth to power.
But truth is the word.
Yes.
And that was the issue.
And that's all I spoke. And I spoke it to power, and I paid the price.
This is Floyd Abrams, and this is Speaking Freely. And I'd like to talk to you today about something that all of us have talked about for some time. I want to go back to Johnny Depp and Amber Heard and talk a little bit more about the differences between our law and that in England, and a little more about the case. It's hard to believe, in a way, that it ended just 2 weeks ago from when I'm speaking to you now. But it was just 2 weeks, and yet, as things like this happen, it starts to fade a little bit from memory. I want to talk first about what Amber had to say. Basically, she said that she was telling the truth. Her problem, her legal problem, is that the jury didn't believe her. The American jury didn't believe her. And that is the core of what happened in the trial involving her and Johnny Depp. Let's go back a little bit in time, though. She had some reason to be really optimistic about this case because, as you'll remember, this was not the first case. There had been a case in England in front of a judge, and in front of a judge who concluded in so many words, I'm reading it to you now, that she was the victim of sustained and multiple attacks by Mr. Depp in Australia. Now, that was the conclusion of an English judge after hearing them both, after a full trial, and in fact, a full trial under a legal system which is very much pro-plaintiff. Johnny Depp was the plaintiff there. Johnny Depp was the one who said, I'm entitled to damages, etc. And the biggest difference, there are others I'll come to, but the biggest difference between our law and that in England is who has the burden of proof, who has to be the one that persuades the jury. And in the libel case in England, whoever speaks, whoever says something bad about someone else, that party has to come forward and prove that what they said was true. And here it's the opposite. Here, in good part because we think it's so specially important to defend freedom of speech, here we do it the other way. Here we insist that the party suing, the party who says what was said about me wasn't true, was in fact correct. So it's, for a lot of reasons, different systems, but a system in England which favors the plaintiff. And yet Johnny Depp lost, and yet the judge didn't believe him. Now, why the judge didn't believe him, you can guess as well as I. Maybe his American charm doesn't play well across the pond. Who knows what the reason was? But coming into our case, I can see how she would have felt sort of confident because, in a way, the same case, certainly many of the same facts, were going to be heard here as were heard there. let's just pause a little bit and see what the high level of burden is here. Those of you that followed the trial closely will recall the charge to the jury by the judge. But let me just go over the most important part, and it's just a central part now of American libel law. And that is that the United States Supreme Court has imported into our libel law the First Amendment and has said in so many words, in the great case of New York Times against Sullivan in 1964, that in a libel case involving a public figure, the public figure has to prove, the public figure, not the person about whom something was said. The public figure has to come forward and show by clear and convincing evidence that what was said about the public figure was knowingly false. That is to say, the person who said it knew it was false. And if they didn't quite know it was false, had very serious suspicions that it was false. So the English system starts out with everything sort of loaded in a libel case in favor of the person suing and against the party being sued. In England, the Depp case was one he brought against The Sun, an English newspaper, which had, to oversimplify just a bit, sort of taken her side and criticized him. So she had really good reason to think that since a judge in England had already decided, had heard them both, and that judge had decided that Depp was just not to be believed. She said he beat her up very badly, violently, in Australia and elsewhere. He said it was not true, and the judge believed her. And so when this case was filed here, and when trial approached here, American lawyers who follow libel law, lawyers including me, thought this was going to be a really tough case for Johnny Depp. One fact finder had already decided the fact against him, the English judge. And now it was a situation where in order for him to win, he had to prove that what was said about him was said knowing it was false. There were real doubts about truth or falsity. And that's what he did. That's what the jury found. I mean, the jury was charged by the judge that was the legal test. No recovery for him in the suit that he was in, unless he could prove that what was said about him was a lie. And that's what the jury believed. That was the conclusion the jury reached. And it was totally at variance, absolutely contrary to what the English judge had found. So we start there. Looking back on it, I think of my own reaction when the case was about to start here. And like I think a lot of American lawyers who've been involved in cases like this, we thought that, given what the judge had found in England, it's supposed to be even harder here for the person suing. And for our purposes, I'm treating this case as one case. As you know, she made claims, he made claims. But the basic claims here were his claims. And she had the burden of proving it and couldn't do it. So that's really one interesting side of the case. Now, I find very interesting what she said in that clip that you've seen. And one of the things that she said was that you can't cry fire in a crowded theater. That's close, but not exactly what Justice Oliver Wendell Holmes had to say. He said basically that no one would doubt that if you falsely cried fire in a theater and it led to a panic, that can be the basis for a claim. Again, falsely, and the falsity leading to a panic. But as a legal matter, she's wrong on something even more than that. Her case has nothing to do at all with the sort of situation in which someone cries out, fire, in a theater. Yes, there is a body of law that deals with that, and it's still pretty much what Justice Holmes said way back, almost literally a century ago. And yes, now too, if you cry fire in a crowded theater and it's not true and people are hurt because they're running around to get out of the non-fire, yeah, in that case there will be liability imposed today, just as Justice Holmes said. But it's the wrong sort of case for her to even be talking about. It's the wrong sort of case because we have a body of law which deals with speech where one person says something critical or hostile, and most important, false about someone else. And that's libel law. That's not the law dealing with what happens if someone cries fire in a theater. What it is a separate body of law in which the Supreme Court has made very clear, very often, that the standards to be applied when a public figure, and here certainly the public figure was involved, was that there was a really heavy burden on the person suing in a libel case like this. When a public person, when Johnny Depp sues, or when she sues, or when other famous people sue, they have a heavy burden, and it's meant to be heaven. And the reality of it is that therefore it's very hard for public figures to win libel suits in America. What do they have to prove? They have to show what was said about them was not only false, but that the person who said it knew or suspected it was false. In effect, bad faith. So a public figure here, even if something bad is said about them, and even if it was said without any real effort to find out what the truth was, still can't recover unless there is essentially bad faith, someone who means to go get the other guy regardless of truth or falsity. And that is our law, and it's worked, in my view, very well since 1964, when the Supreme Court first announced it. Now, that law is right now a matter of potential change. There are members of the Supreme Court who have made it very clear that they think that 1964 case was either just flatly wrong or went too far in defending the press or whoever it is that speaks out and says critical things about someone else. And so those of us in this area, and not just us, journalists, writers, authors, people who communicate by words, are very concerned right now that this Supreme Court, our current Supreme Court, could take a second look at this 1964 case, New York Times against Sullivan, and reverse it and go back in the direction of English law. Again, the basic difference is in English law, the burden of proof, the party that has to do the proving, is the one who spoke, not the person about whom it was spoken. That's a big, big difference. And then you need the equivalent of bad faith. Why do we have law which affords that much protection? And the answer is that what the Supreme Court thought in 1964 and what it's thought ever since, until now at least, is that in order to protect free speech, in order to be sure that people feel free and are free to speak out, even if they make a mistake now and then, about public people at least, that absent bad faith, a mistake isn't enough for recovery, isn't enough to allow big bucks to have to change hands. This is all the more important today in the age of the internet and the age of tweets and the age in which not just newspapers, but everybody is speaking out. And everybody has a chance, for better or worse, and sometimes it is for worse, but for better or worse, to have his or her say. The protection of New York Times against Sullivan, the protection that when you talk about a public person, that the public person really has to meet a heavy burden of proof in order to sustain a libel judgment. And again, that burden is to show not just what was said was false, not just that it was about the person who it was said about, but that it was said with bad faith, knowing it wasn't true or suspecting it wasn't true. That's the law the way it is today. That's the law the way it's been since 1964. And that's the law which is imperiled as we look at the Supreme Court today. Now, if I had to guess, I would say I don't think the court is going to throw out that 1964 case. I don't think the votes are there to do it, but there's every reason to think that there are at least 3 votes to do it, because 3 members of the court have already indicated that they're ready to do just that. Now, you need 4 votes on the court. Out of 9 members, you need 4 votes for the court to hear a case. We know there are 3. You need 5 votes, 5 out of 9, to overturn a prior opinion or to write any opinion. But in this case, it would be you need 5 votes to take it back, to say, in effect, we were wrong in 1964 in what we did. So my view is that we ought to hope and do what we can in terms of public opinion and in terms of thinking about things like this, in terms of talking with each other. It's just as a matter of public opinion mattering, because it does. These matters are never pure issues of law. The court is always interested, they're human beings on the court, on what people think of it, what people think, in this case, about freedom itself. So that's where we are. As regards Amber Heard, she ought to take a lesson or 2 in law. I think she's just off base about this. Thanks a lot.